Hey, good evening, everybody. My name is Bouvier Yulin, and I'm the director for SCMA. Welcome to today's virtual town hall meeting regarding SB 940 and SB 1141. This webinar is eligible for 1 hour of MCLE credit and 1 hour of MC3 continuing education credit. If you're requiring MCLE credit for attending this event, please check in by putting your name and state bar number in the chat. Earlier today, I sent an email with a link to the supporting documents as well as the MCLE and MC3 certificate of attendance. If you did not receive it, I will also include that link in the chat. I would now like to introduce our moderator for tonight's town hall, Crystal Williams.
Hello, everyone. Thank you so much for coming to our town hall. I wanted to explain. Sorry, I wanted to introduce our panelists. We have Sydney Kanazawa, Jack Getz, Phyllis Pollock, and Ron Kelly. Right today, we're going to start with Phyllis, who is going to give us a brief summary of both the Senate bills. We're going to move on to Ron, who's going to share some context. We're going to then go to Jack, who is going to give us a perspective of certification from the MC3, and then we're going to have Sydney kind of fill in all the gaps. As we go on, there's a Q&A button at the bottom where you can enter your questions if you have any questions while someone is presenting. And then after they finish their presentation, I'll start reading out your questions to get the answers. After that is done, if anybody has any questions after everyone has gone, feel free to enter them into the Q&A box. Stop time is going to be a hard 7:30 stop. So we'll start with Phyllis and let her start with her slideshow, and we'll get going. Thank you for coming.
Good evening, and I hope everybody is doing all right on this midweek, midweek of midweek. Anyway, I am going to do a very small slideshow setting out what the two proposed bills say and discuss some issues that I see with each of them. So the first one is Senate Bill 940, and what it provides is it adds section 6173 to the Business and Professions Code, and it provides that the state bar may, and notice that it says may, not shall, create a certification program for ADR provider firms, which is undefined. We don't know what the word firms means in terms of the legislative intent, and it can charge a reasonable fee to cover the administrative costs. It then states that the program, if created, must require that arbitrators comply with the ethics standards in Code of Civil Procedure sections 1281.85, and that the mediators are to comply with the California Rules of Court 3.850 to 3.860, which are the rules of conduct for mediators in court-connected mediation programs relating to general civil cases. It also provides, and as I point out, no experience is required. You just simply have to follow these rules. And then it also provides that the ADR provider firm has a complaint procedure in place for the non-complying arbitrator and mediator. And for those mediators, the procedure should be substantially similar to that specified in Rule of Court 3.865, which is the rule that the ADR panels use to when complaints are made and how to investigate them. And then it also provides that the ADR provider firm has procedures in place to remedy the failure of arbitrator and mediators to comply. And it uses the word remedy, and I'm not really sure what that means. To me, it's ambiguous. Now, the Senate, if you read the Senate Bill 940, it spends a lot of time on arbitrations and arbitrators, but since this is the Southern California Mediation Association, I am concentrating on the mediation aspects of the bill. So there are several issues with the bill. The first and foremost, as I said, is that the term firm is not defined. I don't know if it includes a DBA, an LLC, perhaps a professional corporation. It also doesn't address the issue of the fact that many of our mediators are not attorneys, And I don't know if this bill will cover non-attorney mediators. I read an article in the Daily Journal in which the author of the bill, Senator Umberg, mentioned that the state bar would not have jurisdiction over the non-attorney mediators. And the other issue, which my colleagues will get into, is the fact that it is the state bar that has the ability to create this certification program. And I don't know if the state bar really has the capacity to do that, given how it dealt with the Girardi mess and the other aspects of its discipline procedures. The main issue, I think, and as I said, my colleagues will get into this as well, is that it is creating a conflict of interest in the complaint procedure because it's allowing the provider firm itself to discipline its own mediators and its own arbitrators. And to me, that's pretty much like the wolf guarding the hen house. It also points to using the rules of court 3.850 to 3.860. And if you read those rules and contrast them with either the California Evidence Code statutes governing mediation or the model standards of conduct for mediation, you'll find a few conflicts. For example, Rule 3.852 defines mediator as simply the person who conducts the mediation, whereas if you look at Evidence Code section 1115, it defines mediator as also including the assistant or essentially the case manager. So you have some conflict there. Rule 3.855 talks about impartiality and says the mediator should be impartial both before and during the mediation, whereas the model standards of conduct say that the mediator also has to be impartial subsequent or after the mediation. This California Rule of Court also says that where there are more than two parties, if let's say one of four parties object, the mediator can still go forward with the mediation with the other three parties, which I think most of us would find not to be the best way to proceed, that we would simply recuse ourselves completely. But yet the California Rule of Court will allow the mediator to go on with the non-objecting parties. And in terms of impartiality, these California Rules of Court ask you to look at the Code of Civil Procedure section 170.1, which talks about disqualification of a judge. And if you look at those disqualifications, I think they're a lot broader than many of us as mediators would look at in determining whether we have a conflict of interest. What I think is also troubling, and I mentioned this when I teach mediation ethics in my class, is Rule 3.857 little d. It provides that the mediator can offer evaluation or opinions and can also posit her view of how the law applies to the subject matter. In other words, provide legal advice. And as we all know, we are not to provide legal advice. We can offer information, but not legal advice. But yet this rule, and particularly the comment to it, seemingly indicates that we can do that. Finally, Rule 3.860 requires an attendance sheet that we keep for 2 years and submit it to the court on request, which, as you can guess, would breach mediation confidentiality. So those are my quick comments on Rule 940. Let me go on to Senate Bill, to Senate Bill 940. Let me go on to Senate Bill 1141. Senate Bill 1141 amends California Code of Civil Procedure 1775.5, and it provides that the court shall not order mediation unless the following conditions are met: that the amount in controversy is up to or no more than $150,000, that the matter has been set for trial, that at least one party has shown an interest in mediating, that counsel attending the mediation must have full authority to settle, that the parties are notified that they may stipulate to a particular mediator or the court will select one on a pro bono basis, that the mediation must be completed at least 120 days before trial, and that an amount and controversy determination in a subsequent trial de novo or by a mediator is without prejudice. Now, the words that I've underlined in yellow or highlighted in yellow, I am told will be deleted when the bill goes before the General Assembly. As you can see, if the terms by a mediator is included, excuse me, that is contrary to much of what we have learned as mediators. You know, first of all, a mediator is not a decider. A mediator is not an arbitrator. We make no decisions, but yet this proposed statute as written would have us basically be an arbitrator. Code of Civil Procedure, Section 1775.5 is part of a larger statutory scheme, which is the Civil Action Mediation Act, 1775 to 1775.15, that was acted in 1993 as a pilot project program. And the issues that I see with this proposed statute is that it is not totally consistent with other parts of the Civil Mediation Act. For example, the first statute in the Civil Mediation Act, 1775.2, says that the act is mandatory in the county of Los Angeles, but is discretionary in all other counties. So I'm not sure how strong this proposed bill will, what the effect of it will be if it is discretionary in every county other than Los Angeles. It also, while 1141 provides that the parties have 15 days to agree on a mediator, if you look at CCP section 1775.6, it says the parties have 30 days to agree to a mediator, but if they don't, then within 15 days, if no mediator is chosen within 15 days, the court selects one. I don't know if that's ambiguous, if it's consistent, or what. 1775.8 says mediators are to be compensated. 1775.9 says a mediator shall file a statement of non-agreement, and then the matter is to be calendared for trial. So the Civil Mediation Act now provides that trial is not to be calendared until after the mediation, in contrast to this proposed bill. 1775.10 says that all statements by the parties are subject to Evidence Code section 703.5, which provides that mediators are not competent to testify, and to Evidence Code sections 1115 to 1129, which are our mediation confidentiality statutes. And so again, if the word by a mediator is not taken out of this statute, it's directly contrary to this statute. And then 1775.12 also says that any reference to mediation or statement of non-agreement that occurs in a subsequent proceeding is grounds for a new trial, which I think is also in Evidence Code section 1128. So again, hopefully, when this bill gets to the General Assembly, the words by a mediator will be deleted to avoid all of this inconsistency. If you also look at the Evidence Code sections, the terms by a mediator would also be inconsistent with sections 1119, which talks about confidentiality, 1121, which talks about no reports are to be made, 1123, which talks about the enforceability or the admissibility of an agreement, 1126, which provides that what goes on in mediation stays in mediation forever, and then 1128, which, as I said, that any reference to a mediation in a subsequent hearing is grounds for a new trial. So the other issue that I have with this is the comment that counsel attending mediation must have full authority to settle. And I am told that this may well be changed so that it complies with the rule 3.894A that talks about where the defendant or where one of the parties is a governmental entity or an organization, then simply then a representative can appear and just be able to make the recommendation to approve the settlement to the city council, the board of supervisors, or what have you. So anyway, that is the two bills in a nutshell. And with that, I will turn it over to Ron so he can give you the legislative background.
Thank you so much, Phyllis. Go ahead, Ron.
First of all, thank you, everybody who's here tonight and who's watching this, for your interest in the legislation. I was pulled into lobbying over 30 years ago when a bill was carried by the Senate Judiciary Chair at the time that would have removed mediation confidentiality. And I've been actively lobbying on our mediation laws ever since then. In terms of fundamental principles, I sincerely believe that disputants being able to be truthful with a mediator is a real service to our society. And I sincerely believe that voluntary agreements, uncoerced by a mediator, are also a service to our society. And I've focused on those too. Some of you probably understand the intricacies of shaping our laws better than I do. Some of you may know very little about it. I want to make two main points and use these bills as examples, put them in a historical context, really, of that entire 30 years. One, it takes a long time, I found, to understand how the legislative process actually works that creates our laws, who the influential stakeholders are that can get amendments stuck in at the last minute when they want to, and how to understand and respect their often conflicting interests. The most recent amendments to these two bills exemplify what happens when legislators and their staffs, who really cannot know any particular area in depth or the unintended consequences, try to solve a problem through legislation, which happens pretty regularly. For instance, on Senate Bill 1141, Ellie Valendra built support for it, got the organized bar associations, the judicial branch, the Los Angeles County Court, and others to say, let's just raise the statutory cap on court-referred mediations from the old number from 30 years ago, 50,000, to 150,000, mostly to adjust for inflation, but a little extra. Pretty simple bill, right? But then the plaintiffs' bar, which has consistently for decades said, we don't think it's right to be forced to attend and pay for mediations, which they were regularly being forced to do in the larger cases. They came around and they said also, their view is generally that insurance carriers are hesitant to offer reasonable settlements until trial is imminent. So quite suddenly, a couple of days before the bill is heard in Senate Judiciary Committee, there are several major amendments, which the author has to accept if he wanted it to pass out of committee. Just one of those, as Phyllis mentioned, flips the order of when mediation happens. It was supposed to be mediating, and then if they couldn't settle it, setting a trial date. And suddenly it's now, you need a trial date before you can have a mediation under this program. It's just one of a bunch of different amendments that all happen at the last minute. Please understand that this bill, like so many others, the committee had almost certainly already decided how they were going to vote before the public hearing. That's very routine, and it was a shock to me to find that out. They all know how they're going to vote. Almost never does anything actually change at the public hearing. And they voted to approve the bill, SB 1141, and all these major amendments before any of them ever got to read the actual bill text they had voted to approve, which didn't come out for several days after the vote. Keep in mind that by the time many of you even found out about Senate Bill 1141, it had already passed unanimously through the Judiciary Committee in the Senate, through the entire Senate, and it's now scheduled for a hearing in Assembly Judiciary this coming Tuesday. And the deadline for submitting any comments you might have wanted to make has already passed. Committee deadline was this past Tuesday, yesterday, noon, to submit any comments. It happens that fast. On Senate Bill 940, the bill in print before its committee hearing said, okay, we're going to authorize the state bar to set up a certification program for ADR firms. But suddenly, a couple of days before the bill is going to be heard in Senate Judiciary Committee, there are again major amendments, just one of which would change arbitration law to authorize discovery in all arbitrations, as an example. It's the arbitration provisions that are probably the main reason this bill is either going to become law or be vetoed, as a similar one was previously by Jerry Brown, or be overturned in federal court as preempted by FAA. We mediators are small fries in a lot of these big legislative fights. Second point I want to make. There's two different approaches to creating the statutes that govern our field and getting relevant legislation either amended or killed. One is based primarily on professional lobbyists. The major players, like the plaintiff's bar and the defense bar, have paid lobbyists. Those lobbyists understand very well how laws are actually made, who the main players are, how to get access to the legislative staff and legislators, and how to advocate for what they see as their interests. For those of you who don't know, we mediators have a lobbying organization too. I urge you all to become paying members of the California Dispute Resolution Council. You can find it online, California Dispute Resolution Council. I've been a member since its founding. It's a very necessary organization. Lobbyists are expensive, and that's mostly what our dues pay for. But the other approach is one that I've personally used for 30 years now, and which Sid encouraged me to share with you, so I will. My own approach to lobbying has looked a lot more like a very large-scale public policy mediation. I've always tried to understand the divergent interests, communicate my respect for them, including the lobbyists on all sides of this kind of stuff, for the difficult work that legislators and their staff do in trying to understand what their bills even would do. I've consistently advocated, but I've focused very narrowly on establishing and maintaining mediation as a safe place for disputants to speak truthfully. Disputants on all sides of any conflict. As specific examples, I've been exploring the potential impacts of Senate Bill 1141 with people all around the state since it was first proposed at the Conference of California Bar Associations last year. When the problematic amendments first appeared a couple of days before the hearing, I immediately began trying to communicate with people all around the state to identify what's the smallest possible changes we might be able to get into that law that would protect the integrity of mediation, and then to persuade the author's office and committee staff to approve these minor revisions. When SB 940 first proposed the certification guidelines, I tried to identify with others around the state the very smallest revision possible that seemed necessary to protect mediation confidentiality, and then try and get the author to approve it. My efforts on both of these bills were successful to the best of my knowledge. We won't know till we see the final bills in print and signed. I want to just say, though, that I'm 75 this year, and I'm not going to be able to continue putting in the time I have. On average, I estimate I've spent somewhere between a half day and a full day nearly every week for 30 years. Learning the legislative process, tracking bills, creating and affecting mediation laws, mostly in California, but sometimes on a national level. And if even one of you here this evening or watching later is interested in the mediation activists' approach to shaping the laws that govern our field, please go look at my website. That's ronkelly.com, one E in Kelly. Pull down the resources tab and look at crafting ADR law and policy. I've done my best to give you concrete examples of a mediation activist's approach, and I hope at least one of you finds that useful. And with that, I'll turn it over to my fellow panelists. Thank you.
Thank you so much, Ron. So now we're gonna have Jack Getz share some information about the MC3 letter that was drafted. That is also included in your handouts.
By the way, I see a Q&A, one of those. Were you going to take those as they come
So
up or later?
yeah, this one is actually a comment, and I believe everybody can see it now that it's open. It just says that mediation completion 120 days before trial invites further trial delays and perhaps lessens pressure. That was a statement by Marlon Schulman. All right, Jack, take it away.
Thank you, Crystal, and thank you, SCMA, for setting up this panel. It's a really important discussion. I think, we've gotten right to the details, and sometimes we miss the big picture. And I'm going to focus mostly on the big picture here with SB 940. MC3 has stated its opposition to SB 940, and even though we have been in the business of voluntary mediator certification and agree wholeheartedly that it could be done, we don't believe the state bar is the right entity for it. And for a lot of reasons that are in the legislation, which I'll go through, that in its current form is not really ready for prime time. My hope is that after I talk today, that many of you will find a way to make your voices heard. And SCMA, certainly as a large organization, maybe the largest of its kind in the state, its voice is very important in the ongoing battle around SB 940. So SB 940, again, is about voluntary mediator certification. It proposes that the state bar organize a voluntary mediator certification program and charge you for it. It has a lot of other, little intricacies with it. But first, the reason why MC3 is so concerned, we've been doing voluntary mediator certification, and we've walked the walk now for over a decade and know what it takes to put together a solid voluntary mediator certification organization. MC3 started as a task force for SCMA. Former President Barbara Brown organized a task force in 2013 because she and many members of SCMA were concerned about a 2012 bill being introduced in the Assembly, which again had the state bar overseeing mediators. Fortunately, that bill didn't make it to a vote. It died in the Assembly, which was great because many voiced opposition. A lot more opposition than has been voiced so far to SB 940, but I think hopefully more will come. So there was an aborted attempt by the Assembly for the state bar to take over oversight of mediators. It caused Barbara Brown, former SCMA president, myself to form a task force. We researched for a year what should be done proactively in the mediation area, whether it should be licensure, whether it should be voluntary mediator certification. We produced a white paper that was delivered at the SCMA annual conference in 2013. SCMA enthusiastically supported our conclusion that voluntary mediator certification was the way to go. And they tasked us with going out into the community and trying to formulate standards and how it could be done. So we spent 2013, 2014, 2015 running town halls throughout the state. We were benefited greatly in running those town halls by someone who's actually online here with us tonight, Alan Weiner, who spent many years with the Judicial Council in formulating mediation policy for the courts in the state, who went with us around the state, San Francisco, San Diego, Orange County, Los Angeles, and we processed evolving our mediation standards. They've never stopped being processed. We have a qualifications committee now that meets 5 to 10 times a year, just continuing to evolve the standards. With the state bar looming as overtaking mediator certification, you sort of wonder how they're going to develop that kind of expertise. Anyway, MC3 launched in 2019, and the idea was a couple things. First, that we would emulate more of a formalized profession. So formalized professions have binding ethics codes. There's a grievance policy and continuing education, amongst other things. So we embodied all that into the MC3 certification process. The second idea, which is embodied in our standards, is that voluntary certification should be based upon your abilities as a mediator and not whether or not you have a law degree. Those things are not necessarily related. And, unfortunately, many of you know there's courts throughout the state that won't accept people without a law degree. And the bias is so strong, and you've all heard it. And I've ranted about it for years, and I don't think I'm going to be able to change it. Like Ron, I'm in my 70th year, and I've devoted a lot of time here. I'm not quite sure I'll be able to make a change. But how many times do you hear people say, you're a non-attorney mediator? Or we call ourselves, we're non-attorney mediators. Does anybody in any profession, in any field, identify themselves by what they're not? I'm a non-female presenter. I mean, this is, think about it. It's embedded in the field. So we bear some of the responsibility. But, going on to SB 940. So we had these two things to unify the mediation, the field into a profession, make it more like a profession. And so SB 940 seems like it could do some of those same things, right? They're proposing voluntary mediator certification, which is what MC3 does, but there's no detail. There's no way to know whether or not the certification that's proposed in that legislation is going to raise the standards or up our practice in the field of mediation. It's up to the state bar really to do that. And how is the state bar going to do that without the background in all of this? So while we support SB 940, we wrote a major letter of opposition. I'm going to put on my screen some of our major points. I know our time is limited today, so I'm not going to go into tremendous detail on this. But when we wrote our letter on April 19th, we had 4 primary objections to the bill in its format at that time. First, there wasn't really anything about mediation confidentiality protections that were provided by the alluded to grievance process. And here, he's so humble, and I'm so honored to be on this panel with him, but Ron Kelly gave us a big assist because he had been working diligently on this issue by the time we had even sent our letter. And sure enough, they have built some semblance of protections, although, as Phyllis has pointed out, it's not bulletproof for sure. But they base it on what's been being done in many of the superior courts throughout the state, a grievance process that's protected by confidentiality, very similar to the process MC3 has developed for its certified mediators. So that was one part of the letter that, again, huge assist from Ron Kelly, we were at least able to get some legislative changes on. But the second part, the state bar as administrator of the voluntary mediator certification, again, I don't know, and Phil has talked about this concept of firms and whether it would apply to people who did not have law degrees or weren't members of the state bar. All that's sort of unclear. But even the appropriateness, if it does involve the mediation field of oversight of mediators who do not have a law degree, what's the state bar doing in that? Do they even understand the kinds of cases we work with? What about if it's not a litigated case? What does that mean to the state? Would they have any background or expertise? What is the state bar's experience, or probably lack thereof, with mediator ethics codes or mediator qualifications? Alan Weiner, who was largely the author of this bill, proposed to the legislator that the Department of Consumer Affairs might be the appropriate agency. Now, first, many of you know the Department of Consumer Affairs. They are the oversight agency for the DERPA statute, the Dispute Resolution Programs Act. So they do have some background, obviously, in mediation, training, qualifications. What we didn't know, and Alan did the research on, was that they also have certification or licensing procedures for a variety of other fields. So it made sense to us that that would be a better place for the bill to house voluntary mediator certification. We wrote that in our letter. We've since heard from the senator that he's not inclined to make a change at this time. That doesn't mean he won't later, but there's those concerns. I would say a side concern for all of you is what's going to happen to the diversity in our field. I mean, the bill talks about ADR firms. Who are they? And Phyllis brought this point to bear already. There's, does it cover individuals? And aren't the individuals the ones that bring diversity and resonate the values of our field? And what does it mean? A lot of you, I mean, there's all sorts of concerns about the state bar. I don't know if any of you have seen what they charge for the bar exam recently. I mean, I think it's $850 for a law student and $1,500 for an attorney who's taking the exam. Again, NC3 wrestles with its own certification costs and what is appropriate. And I just don't know, by giving the state bar license to charge for this process and also identifying firms, whether or not they have us as individual practitioners in mind and what that charge might be. Again, it's a side issue, but it might be important. Will this bill operate as a means of, taking the diversity and the inclusiveness of our field and wiping it out? I can't say in looking at it. Third point, again, I think, as Phyllis said, that the author said something to the effect of, well, if they're not members of the state bar, they won't be covered by the bill. That might sound good to a lot of you. I think it sounds horrible because it means that if you're not a member of the state bar, then you won't have the same opportunity to be certified as the people who are. So many of us believe there's a bias already built into our field. Now we're legislating that bias. So I think that's a big issue. And I think that's another reason why we should be opposed to the bill as it's currently constructed. And finally, Phil has talked about this. I mean, if there's a consumer protection angle to having this voluntary mediator certification, in other words, that's one of the reasons MC3 has had success. It's a consumer protection idea as well, because all the mediators are bound by an ethics code, et cetera. But you sort of remove that layer of protection. Under the current bill, the ADR firms actually process the grievances against them. If you can imagine, that would be like you having some pecuniary interest with a disputant, and suddenly you're mediating that dispute. It's crazy to think about it, that would actually be coming into our field. So we obviously wrote about the need for a neutral party. And if the state bar is going to be the oversight agency, they might even be the neutral party. But you can't have the firms, I think Phyllis had the wolf guarding the hen house. I might have the fox, but it feels the same way. It feels like the fox is guarding the hen house, and that doesn't feel right, at least for our field. So again, I'm going to wrap up my time. I'm sorry I've taken maybe over the amount of time I was allotted, and encourage all of you to come up with questions. And thank you so much.
Thank you so much, Jack. So what I'm going to do before I move on to Sid is I'm going to read the comments that are in the chat box. Mediator Ron says, with regards to what Ron Kelly had talked about, he says, in his brief experience of legislative action, it's almost impossible, as Ron said, to make any effective changes unless you have support from a wide variety of sympathetic and related agencies and groups. The legislators simply won't pay attention to us without those groups behind us. Thank you for that comment, Ron. I have another comment here from Jim Lingle. Says the very concept of having the state bar oversight of mediators is to force us to become members of the state bar. And then Bruce Paul says the real question is whether the state bar will actually do what the law would legislate them to do, or will they make their authority a reason to exclude mediators from any legal action entirely? So thank you guys who put some information in the chat box. Sid, do you want to talk about how this process might impact volunteer mediators who do work in the courts? I know that's something that you have done and have a lot of experience with, and anything else you'd like to share, feel free.
Yeah,
You're still muted.
I'd like to thank Phyllis and Ron and Jack and Crystal for their presentation so far. And I think what all this suggests, as much as there's a lot of holes and problems in the whole thing, Ellie Villander was the one that initiated this raising of the threshold amount from 50,000 to 150,000. And she went around to all the bars and proposed this and got a lot of approval from the various bars and eventually presented it to the legislature. The idea of raising that threshold is movement in the right direction. It is the original $50,000 was part of a pilot program, as Phyllis has mentioned, and it was really to change the culture in the 90s to accept ADR, accept mediation as a way of resolving cases. In fact, the legislation talked about not only the efficiency of getting the cases resolved early in a fair and equitable manner, and reducing the cost and time and stress of disputes, but it also talked about reducing backlogs. And if you read the preamble to 1775, CCP 1775, almost all of those items there can be applicable to our situation right now. But it was a pilot project designed to change the culture of how we resolve disputes back then. And I think that what's happened is that in this effort to change the culture, the legislation doesn't appreciate that the culture has changed. And the culture has really changed a lot since the pandemic. One of the things that has changed since the pandemic is this platform, online mediations. And I think that what almost everybody has found is that the online platform has made this concept of mediation very, very easy, very convenient. People can get together on this platform and talk and see each other in a manner that was not possible before. And we had to kind of drive through all the traffic and spend an hour or fly into LA or do whatever it had to do to be able to meet face to face. And now we can do that, not only within the city, but within the country, within the world, and we can connect with each other on this platform. And that has changed the dynamic of mediation. It has made it much easier to start the process very early, whether it's a volunteer program or whether it's a paid program. I think we've all found that it is very easy to start the process at the very beginning. Probably the most important thing about starting the process early, and this was part of the original legislation, is talking about how do we move this discussion earlier so that we don't get involved in all the discovery and everything else that goes forward, is the idea that we can talk about this discussion. And I think that the reason that the plaintiffs' bar and a lot of people were reluctant to have these early discussions is because the logistics of getting together was so difficult that nobody wanted to do that unless we were up against a trial date. Because I think in the beginning, when we were changing the culture, the thinking was that we had to force people to agree. We had to have some kind of event that was about to happen, a trial, a motion, or something, a big discovery that would force people to resolve the matter. In fact, I remember as a practitioner that I was looking for mediators who could twist arms and force people to agree. That was the thinking that we had in ADR. But I think that we've evolved, and I think that as we've come along, we've realized that forcing people to do something does not get them to the goal line. You know, we've got wars in Russia and Ukraine, and we've got wars in Israel and Gaza, and we can see all over the world that force doesn't necessarily mean that everybody's going to bow down and say, okay, let's agree. In fact, what we found in recent years is that listening to people is far more effective than forcing people or trying to impose our will against other people. And there's been a lot of books and studies, and it's nothing new. Aristotle talked about this thousands of years ago, and a number of people have thought about how do you persuade people. And essentially, the idea of persuasion is not so much forcing people to do something as much as it is what Ron was talking about listening to people, about understanding the different perspectives that people have about this bill or whatever the dispute may be, and to figure out how do we agree. And so the idea of mediation and ADR essentially is taking this binary system that we have, which is plaintiff versus defendant or anything like that, and transforming that binary kind of us, them, winner take all, zero sum type game into a collaborative effort where we work together to solve a problem. And so it is necessarily a different kind of an approach to resolving disputes than the litigation and traditional types of plaintiffs versus defendant type of a situation. And because of that, a lot of our thinking as this evolution is taking place of us accepting ADR, accepting the idea of mediation, has been a transformation from this warrior type of mentality to this more collaborative type of approach. And what we see in this bill and a lot of the things that we've been critical of tonight is that it still clings to this idea that we have to be opponents, that we have to be against each other in order to solve a dispute. And I don't think that that's where we are now. And we are moving towards a better understanding about how we can resolve things. And it's resulted in much higher resolution rates, much greater satisfaction, much faster mediations than we've ever had in the past, in part because of this transition to a new medium, Zoom, and a new understanding about what we are actually trying to achieve in this mediation process. And so when we, part of this, start and stop evolution that has been taking place in accepting ADR and mediation and the like, has been our understanding and misunderstanding about what mediation is. And I think that in the beginning, there's a lot of talk about mediation is a voluntary agreement. But it's hard to reach a voluntary agreement unless you have people willing, as Ron said, to be able to come forward and feel comfortable telling the truth, being honest about their situation, which means that we have to have a certain amount of confidentiality so that people feel willing to tell the truth and to exchange ideas and to not be just a cheerleader for their side. And we see it in our social media that we have today, that when we have public debates, it's very difficult for anybody to concede the wisdom of the other side. And it's because we're all like cheerleaders in these public debates. And it's almost like you have to be strong. You have to be vehement about your side. You can't concede. You can't agree with the other side. But in a confidential setting, In a confidential setting, that gives us an opportunity to take off our armor, to kind of work together and to not be on opposite sides of the table, rather be on the same side of the table and work together to solve a problem that we can put on the other side of the table. And so the issues that are being presented, I think, with this 940, which the primary problem, I think, is that it is asking the state bar to be the potential certification agency, is that the concept of lawyers is to be a representative and an advocate of somebody, of a party, of a government, of something. And that's the antithesis of what mediators do. We don't represent any of the parties. In fact, we're trying to be neutral and trying to bring people together. And so the whole concept of the state bar and being a lawyer is actually the opposite of what mediators do. The second problem with the whole concept of the state bar being in charge of this dispute resolution process is that in SCMA, half our members are not lawyers. And when I tried to do some research nationwide about mediators, it's consistent that half the people that are ombudsmen and mediators and HR personnel and social workers and all the people that are involved in resolving conflict, those people are not necessarily lawyers. And so the idea that it has to be stuck into this binary type of setup of plaintiff versus defendant and lawyers representing each other zealously, that concept is the antithesis of what actually we do as mediators and trying to bring together people. In 1141, the idea of raising the limit makes a lot of sense. I mean, we should be doing all the cases in mediation and all that. But the idea of having to set an agreement, I understand why the plaintiffs bar will want that, because they want to make sure this is going to be worthwhile, that it's going to be something that will be productive. And so they feel like they have to have a backstop, something that will force people to make a decision and all that. But I think as we evolve our culture of mediation, we'll start to see that, being adamant, being vociferous about a position is not the best way to resolve a dispute. That the best way to resolve a dispute is just simply to have this idea that we got to work together, and we have to do it, in a setting where we can be honest with each other, and that is not necessarily a setting that is close to trial. It is at the very beginning, and because of Zoom, we have the ability to talk to each other at the very beginning, but it requires all of us to be reciprocal in the way that we treat each other, and treat each other, as Ron was talking about, in terms of trying to put together, a resolution among various interests. That we have to be respectful, and I think that sometimes we forget that just because it feels right to be a warrior and promoting an idea doesn't necessarily mean that it's the right way to figure out how we can live together, how we can work together and move out of the past and into the future.
Awesome. Thank you so much, Sid. So what I'm going to do next is read the remainder of the comments that came in as Jack and Sid were talking, and then I'm going to pose the question that is in the Q&A, and then anyone on the panel can respond to it. So Ivan Stevenson said, you cannot be a member of the state bar unless you're an attorney. Thus, it is an effort to eliminate all mediators but attorneys, which is wrong. The problem is the state bar has proven its incompetence in the discipline area. As a member of the bar since 1974, the only areas they have excelled are the special master program and fee dispute issues. The licensing of attorneys has even fallen by the example of incompetent attorneys that he's seen, not just as trial attorney, but also in mediation. Another comment, Jim Lingle made reference to relative effectiveness of mediators and attorneys, mediators in a court annex mediation program. Not exactly clear on what that relates to, but I wanted to not leave that out. Fern Salka says, on a side note, I'd like to suggest that in the field of family law, we no longer call our mediators ADR providers. The alternative suggests the primacy of litigation, but rather CDR providers, consensual dispute resolution, which identifies what we do without indicating which dispute resolution process is primary. In more progressive jurisdictions, they call it PDR, primary dispute resolution, but that has clearly been a bridge too far in our litigious adversarial culture. I suggest we all adopt the use of CDR as language both affects and reflects our values. Thank you so much. Marlon says, thank you all for the in-depth and thoughtful presentation. It's amazing that it's gotten this far again. More thoughtful, broad thinking minds are sorely needed at the legislative level. Jim wrote a book, No Differences Between Mediators and Non-Attorney Mediators, which is available on mediate.com. And Marcy Barrett says, my mediation practice focuses on elder family mediation. It is most often non-litigation or pre-litigation matters. Participants are rarely represented by counsel. It feels wrong to me that the state bar should have any involvement or oversight. I'm also a lawyer and a member of the state bar for 35 years. This feels like to me another way for the state bar to make more money. Ivan agrees with that sentiment. The state bar wants to raise bar fees. To answer Scott, the video will be available for reviewing. That is why it is being recorded. Bruce Paul, so how to be a proverbial David without a weapon? Phyllis, I see you have your hand up.
Yeah, I have a question for Ron. In my presentation, I mentioned a lot of inconsistencies, particularly with the Civil Mediation Act, section 1775.1 to .15. In your experience, what does the legislature, if anything, do about that, or how do they clean it up or get rid of the inconsistencies, or do they?
There was somebody who was up in front of a legislative committee once who was pointing out that what they were doing was entirely contrary to existing law and various court decisions. And somebody on the committee stopped them and said, I don't think you understand what's going on here. We make the laws. They are quite happy to change the law when there's something new that's inconsistent. The later statute is considered to supersede the prior statute. And if nobody pays any attention to it, then the legislature by and large says, look, we do broad brush stuff. The courts will figure out if there's some conflict between existing statutes or what was there before. I don't find that legislators have the attention span having to vote on 3,000 bills every year to even understand fully what they're voting on, let alone having somebody sort out this conflicts with what's already in this main scheme we've been doing. Ideally, somebody in the Assembly Judiciary Committee staff, and that's currently the guy in charge of analyzing 1141 anyway, is the deputy chief counsel. So he's been staff member for a while. Hopefully he'll catch a few of these things and say, the committee recommends the following changes. And that's, for people who don't know, the committee staff has a huge, huge impact on those kinds of things. So does the chair. If they catch it, that's where they'll catch it. And if they don't, they'll figure that the courts will work it out. That's my experience.
Thank you so much, Ron. So we have one more comment from Elizabeth Miller Bugdanos. I think that I said that correctly. Forgive me if I didn't. State Bar is broke and very much looking to increase its sources of funding. Ivan K. Stevenson says, Ron, what was the source reasons for these bills? In the past, the attacks on confidentiality came from an event. What was the prompt point for these bills?
Hi, Ivan. So on 940, which is carried by the Senate Judiciary Committee chair, Senator Umberg, like so many people, looked at the corrupting influence that Girardi had on the state bar, on the profession. He looked and saw that people who were called mediators by the Los Angeles Times in their reporting, who in fact were not, they were special masters appointed under court authority to distribute funds that had already been decided. How much is it? They weren't acting as mediators at all, but he looked at this and he said, well, they were called mediators in the press. There are a bunch of mediators. He was particularly unhappy with the large firms, JAMS and AAA, and said it's time to do some oversight of a field that has too little. And he feels he's doing the right thing. Senator Umberg has been somebody who's tried to do what he believes is the correct kind of oversight in other manners as well. That was the impetus for SB 940. In terms of 1141, to the best of my knowledge, it was Ellie Valendra, who is the subcommittee chair for the ABA's dispute resolution section on early dispute resolution. And she really believed that it was appropriate to have more early dispute resolution, that the $50,000 cap was just too small. It was set 30 years ago, and she wanted to enable the courts to refer more people to mediation in larger cases. Basically just adjusted from inflation from 30 years ago with a little extra. Those are the two impeti for those two bills.
Thanks, Ron. So we have a question here in the Q&A. It says, of the 58 county courts in California, how many of them have mediation programs that are 1775 programs? Most in Southern California are not. So how much of an impact would 1141 actually have?
Well, as I said, if you read 1775.1, it says that the program shall operate in LA County. So it's only mandatory in LA County. I don't know how many of the other counties have some sort of discretionary program. The thing about LA County, that while it's mandatory, it no longer has a ADR panel. The court ADR panel, I think, was done away with in about 2012. And the court has now outsourced its mediations to a group operating out of the San Fernando Valley. I forget what the name of it. But the issue that raises and is that the outsourcing group, I think, will be charging reduced rates, and under a very old appellate case called Jeld-Wen, JELD-Win, WEN versus Superior Court, the appellate court held that you can't force somebody to go to mediation and pay for it. And so the LA Superior Court had a pro bono ADR panel so that they could order somebody into mediation and have them go through the pro bono aspect of the panel. But now that LA Superior Court does not have a pro bono panel, I'm not quite sure how it can implement 1141 if it passes, since it's the only mandatory jurisdiction under the Civil Mediation Act. I don't know if Sid has any comments he'd like to add.
There's a resolve. There are voluntary programs between the plaintiff and defense bar, the resolve program. There's a Sankey program out in San Fernando Valley, and there's various programs. The Department of Consumer and Business Affairs runs a program in the mosque, our mosque, and all that. So there's a lot of programs out there. Significantly, though, the bill regarding requiring the 1140 requiring a trial and requiring that if they order the case to mediation, it be done at no cost to the litigants, doesn't mean that it's pro bono. In fact, the original bill provided for some compensation for the mediators in the system. Well, the original pilot program involved some amount of compensation in that context, and it was even that it was going to be similar to arbitrators, something like that. There was an mandatory arbitration program that was also experimented with at that time, and so there are a lot of ways of doing this, but I think that the whole idea of both the original 1775 and these bills is to change the culture. And I think that we are in the process of changing. And I'll give you an example is that right now I and a few others are doing status conferences rather than mediations. And so instead of setting a mediation 6 months or close to trial and not talking to the parties until that time, we talk to the parties as soon as they ask us to get involved. And so it might be even before the case is filed, before the litigation is filed. It might be immediately up a litigation. This happened in the pandemic, that in the beginning of the pandemic, everything shut down all of a sudden. And I had a whole bunch of cases that were assigned to me that had not conducted any discovery whatsoever. And so the parties didn't have enough information to be able to negotiate. And so what we did was we converted this Zoom platform into a status conference platform where we started to talk about what information do you need to be able to rationally negotiate this particular matter. And we talked about how we're going to get it and how we're going to transfer it. And this is in the middle of a pandemic. And so these status conferences were like 5 or 15 minutes where we just kind of kept up with each other as to what's going on and whether the information is being exchanged and the like. And then in the process of doing these exchanges, everybody got to know each other. The attorneys got to know each other over this platform, and we're all stuck at home anyway. And it worked out tremendously in terms of helping people to understand each other and not demonize each other and not assume that the other side is completely opposed to everything that we have to say. And that process allowed us to get enough information exchanged and eventually set a mediation date when appropriate. Or some of the cases actually resolved before we even got to the mediation date because we had been talking, and it was this platform that made it possible because we could meet for 5 or 15 minutes at a time, and we didn't have to drive someplace to get there. We could just meet and talk about how we're going to resolve this matter. And it changed the dynamic of us being across the table to being on the same side of the table and working together to try to resolve the disputes. So that was one of the best things about the pandemic, because I think that what happened was we had an opportunity to connect with each other in a way that we wouldn't necessarily do in court appearances and depositions, and certainly not in text messages going back and forth, or pleadings being thrown back and forth, or all those kinds of settings. We had a chance to actually talk and to try to figure out how do we resolve things. And I think that that's probably the lesson of all of this, is that you want to affect legislation, you want to change culture, you want to, try to resolve disputes. I think Jack is teaching people that you got to talk. You can't do it by just writing or announcing your position or anything like that. You got to talk, and so this platform has given us that opportunity to talk, and I think that we need to take advantage of it and appreciate that. Yeah, it's better to be in person, but the logistics of getting to be in person is sometimes overwhelming and doesn't allow us to talk as often and as quickly as we might otherwise. And that's one of the great things that came about from the pandemic and being stuck. So.
Thank you so much, Sid. So we had just a few additional comments before I ask one final question. says, so Phyllis, I think that the organization you were looking for in the San Fernando Valley, I think Lydia offered up that that's called MCLA. Gail Glazer mentioned that she had called out the LA Times and suggested a retraction to their misinformation, but they declined to publish her letter to the editor. Ivan K. Stevenson says, at one time, the court did reimburse the arbitrators and later mediators under the court budget, but as budget cuts occurred, the payment stopped. And Phyllis noted that CCP 1775-8 provides for mediators to be paid, and it was out of the court's budget and quickly dried up. Jailed Wynn versus Superior Court, 146 Cal App 4th 536 2007 says you cannot order a party to mediate and require them to pay for it. I think that both of the questions, new question from David Byers. Hasn't the state bar stated its only mission now is licensing and disciplining attorneys? How does that mesh with certifying mediators?
Jack, that's for you.
All I can say is good question. Doesn't.
All right. So it does not. Thank you so much. And my question is.
Let me add a point
ahead.
that
Go ahead,
I
Phyllis.
think the mission of the state bar is, if you read the State Bar Act, for one thing, we are licensees. But I think it is to protect the public. It is, if you read the State Bar Act, I think it says up front that their mission is to protect the public, consumer protection. And so maybe that is the umbrella that they are using. Ron, you have a comment?
I do. A lot of people think that the state bar has no jurisdiction over people who aren't licensed attorneys. But if you go on their website and you look at their cease and desist letters, which they publish regularly, they sometimes mail letters to mediators saying, we think you've overstepped the bounds of the unlicensed practice of law, and we're coming after you. We're referring you to the local prosecutor for prosecution, so knock it off. The state bar has taken jurisdiction over people who are not attorneys quite regularly.
And closely connected to that, I will remind folks that according to the State Bar of California, if you look at their Bar Rule 2.3b, they consider mediation to be the practice of law. So that if you are an attorney, you must maintain an active license. You can't be, and I think this was more a revenue measure than anything, you can't be a judge who retires from the bench and stays inactive and start being a mediator or an arbitrator. The state bar is requiring those folks to be active licensees. And as I said, I think it's more for revenue purposes than for anything else. Some states, a lot of states do not consider mediation to be the practice of law, but California does, even though we don't have clients and we don't have fiduciary duties or attorney-client privileges or all that other good stuff.
Thank you, Phyllis. Ivan says the state bar is prosecuting the unlawful practice of law by those who do not have a license. Thank you for that comment. So my question is, unless anybody has any additional questions, what can we as members of SCMA, mediators, what can we do now that these Senate bills are here to kind of support them not passing? What is it that the members need to do?
I'm not sure that the main thrust is not passing. I mean, it's kind of going. I mean, the idea of expanding mediation by raising the threshold is not a bad idea, and the idea that there may be some certification, as Jack is pointing out, is not a bad idea. It's just where it's going to be. And so I think that, the procedure of how we go about early mediation is the issue and should be raised with the legislatures and whether we write pieces or talk to people or whatever we do. But I think that the idea of early mediation is a very good idea, but it's being kind of stuck in the old mentality of how we force people to agree. And I think that with respect to the certification, I think it's a good idea, but it's in the wrong place. And that's where I think Jack is pointing out that not only is it in the wrong place, but the idea of it being regulated by firms, who's the firm? And if you're a one-man shop, are you taking complaints for yourself and evaluating the complaints yourself? I mean, it doesn't really kind of make sense. And so it's not that, I mean, everybody has a right. I think everybody has their heart in the right place. It's just figuring out, how this culture is evolving and helping to inform the legislators and the public at large about how we can do this a little bit better. And I think that's all of our jobs. And I think that we mediators have a big job that goes way beyond these two bills. That I think that we have to demonstrate and to model how you get things done. And how you get things done is not by demeaning other people or attacking other people. How you get things done is by what we do in mediation, listening to people and trying to figure out how to conflict is good. We just have to figure out how to work together and live together and use that conflict in a positive fashion. So Jack, I'm sorry, go ahead.
I would just urge that if you're a member of SCMA, that I've been the leadership for either SCMA or MC3 for the last 14 years. It is unusual to have major pieces of legislation that SCMA has not commented on. And I don't see SCMA on the list of opposition to these bills. So I would encourage your leadership to at least, argue on your behalf. I think it's very hard for individuals by themselves to create a change. But I do think, if there's a lot of organizations that weigh in against, certainly SB 940, which is our area of concern for MC3, I think it could be helpful.
Thank you, Jack. I'm going to read this comment and then go over to you. Okay, Ron? It says, maybe the mediation community should create its own organization that all mediators and arbitrators must answer to handle the licensing and disciplining process, not the state bar. And then that was from Ivan. Gideon says, Ron Kelly is right. The legislation is a big public policy mediation. Ron, go ahead. You have the floor.
I was talking to somebody who knows the legislature very well recently, and he said there were really two ways of affecting things. One is a statement from an organization, and if SCMA can coalesce around some consensus on how it wants to approach legislators, it does make sense to try and get on the record. But like I said, the deadline for getting in a position paper on 1141 has already passed. These things happen quick. Trying to form a consensus is difficult. The other way he pointed out that people can be effective is to call their own representatives, their assembly people, their senators, and say, I'm from the district, and here's one thing I want to tell you about my own experience. For instance, I'm not an attorney and I've been mediating a long time and I do with people a lot of good. And this bill looks like it's going to make the state bar in charge of trying to certify me. Could you please talk to the staff and say, that's not a great idea and my constituents care about this? If enough people do that kind of thing, it's going to raise significant questions. I suggest one issue. I suggest reading the bill, trying to understand what it means. After all you've heard tonight, there's a lot of different points you could raise. My suggestion is pick one and call your representative and say, this doesn't work for me. Here's why. Would you consider this alternative?
Thank you, Ron. I'm actually trying to jot down all the language that you just used, because I feel like, it would be a good idea for people to kind of figure out what that issue is. And then maybe if there are a certain number of people who have, think that there's one thing that should be raised and other people, then maybe there's some draft language that could be used to kind of reach out to representatives. I know that that's something that's pretty popular where if a large group of people are opposed to something, they create kind of a blanket statement and, and then people can call their representatives and kind of state that with the fill in the blank and then share whatever whatever their individual issue is. So I think that's a great idea, and I wanted to try to jot that down to share it with the board and membership at a later time. Phyllis, I see your hand up.
Ron, would it make sense for people to attend the public hearings and to testify?
Something you should understand about those hearings, they've already decided how to vote, how they're going to vote before the hearing happens. And generally, the chair says, we're going to agree on 2 witnesses for and 2 witnesses against. And it's really theater more than anything. It's created a public record that they've had a hearing. But if you wait until the public hearing, it's nearly always too late. So my suggestion is to get a hold of your own representatives as soon as possible and suggest one thing that you think is a problem. Ask them to postpone the hearing, if nothing else, until it's handled. I don't recommend making the trip up to Sacramento to try and testify. You may be allowed 10 seconds to stand up at the microphone saying, my name is Ron Kelly and I oppose this, and sit down. But that's probably all you're going to be allowed unless you're one of the 2 witnesses that they've already arranged for and against a bill. They try and hear, 15 or 20 bills in one afternoon, and there simply isn't time to listen to people.
Can you still send a letter to your legislator?
Sure you can. In terms of official positions on 1141, the deadline's already passed. The deadline's not passed.
I understand that, but if you send a letter now, I mean, will it be considered?
By whom? Your own legislator if
Yeah.
you say, I'm from the district and this is a problem I have, and you send it to them. Yeah, among other things, call the representative's office, ask who's the aide that's handling assembly judiciary, and send it to, and what's their email, and send it to them. At
Thank
least
you.
it'll get to somebody and say, I'm from the district, and maybe it'll be considered. Please raise this question with Assembly Judiciary staff would be the way I might phrase it.
Okay. It looks like Gideon posted a link to a way to find your assembly member is what I'm assuming that's for. So I just reshared it to everyone. Brad has his hand up, but he's also asking, can you provide a position letter template to be used to send to the representative? Brad, did I ask your question, or if you still want to say something else, you can unmute yourself and ask the question. If it works that way. Okay, Brad, so you can, I don't know if it'll allow you to ask the question here since we're in webinar format, but if you want to put it in Q&A, I can make sure that I ask the question for you.
He says no in the chat, so I think, Ron, can you come up with a short template?
Not going to do it. I'm sure there's plenty of them on the internet. If you go researching them, I'm sure there's everything you can imagine. But you might listen to the recording of this program again.
Particularly
Brad, I see your hand raised. Hold on one second, guys. Brad, I see your hand raised, but I think in webinar format, it doesn't allow for people to speak live as the attendees, if I'm not mistaken. So if you could just type your question into the Q&A boxes at the bottom of your screen, then it'll bring up your question and I'll be able to ask it for you.
But I will say, I still recommend you find out who the aide is in your representative's office, especially if they're on the Assembly Judiciary Committee, which is the only place you're probably going to have the ability to change anything. By the time it goes through the full Senate Judiciary, the full Senate unanimously, and hits the Assembly Judiciary, by the time it comes out of that committee, they're not going to pay any attention to any of us on the Assembly floor, is my experience. So it's got to happen real quick in the Assembly Judiciary. And you'd want to find out who the aide is. You'd want to call them. You'd want to also send something short and sweet saying, here, you remember we talked this afternoon? Here's my question again. I'd like you to pose it to Assembly Judiciary staff because this needs to be handled well. Something like that.
All right, so Brad has a question. I'm going to hit the allow to talk button so that he can ask his question. Go ahead, Brad.
Thank you so much. I'm following along with what you're saying, and I've worked with legislators along the same vein in other areas, and I agree that they just, do an end around, and they have their own agenda. I was just wondering if that you could provide some sort of a template so that if they say, well, why, we're just all singing the same tune to the same or to any different body of representatives. That's the only reason that I ask. You might have something short and sweet that you've used already. It just makes it as a simpler, way for us to approach our representatives. I'm happy to do it. I can call a representative and go, I think that you should sideline this. I don't believe it's been well thought out. But oftentimes when I talk to my representatives, they actually listen to me and they go, how so? And I'd like to, be able to have something that, you've highlighted in such an eloquent way today.
I think there's two things you can say about these two bills. One, with respect to 1141, they're raising a limit and they're putting conditions on when the court can order a case into mediation. So the conditions are not ideal, but that doesn't mean that the parties can't go to mediation ahead of time. It's just, it's kind of cumbersome the way that it's done. So to eliminate the setting of the trial and when that mediation takes place, maybe you can say something about that. But it's not a bad bill in terms of an approach. It's not the best, but it's not a bad bill. With respect to the other thing, the 940, it says the state bar may start a certification program, so that even if the bill passes, it doesn't mean that it will. It just says it may. And so there's time to be able to say, this is not a right place and to change it. But that's probably the more urgent one, to suggest that it should be someplace other than the state bar. And I don't know, I defer to Jack as to his thoughts on that.
Go ahead, Jack, and we have 2 minutes and I still need to make a closing thank you statement. So go ahead, Jack.
Well, just quickly, Brad, as part of the materials today, I believe MC3's letter on SB 940 was provided to everybody. So that could give you at least some basis, depending upon the points you agree with in that letter, to talk to and to a legislator.
All right, thank you. All right, so we just want to thank everybody so much for coming. Scott is saying a huge thank you to each of the panelists for being wonderful. Your time, focus, and expertise regarding this proposed legislation is sincerely appreciated and inspiring. I would have to agree. I would like to thank all the panelists for agreeing to be on the panel. We'd like to thank you all for your service in the interest of ADR and mediation, especially you, Ron, for having done all this legwork with the legislative piece. I did drop the link in the chat for the mediation. I forget how you called it, Ron. Mediation activists, the California organization. I did put that in the chat box. Hopefully everyone received it. Everybody is just kind of saying how outstanding this is. If you did not check in with your state bar, please email Bouvier at info@scma or scmediation.org. Thank you from Anne Breen Greco. Excellent panel. Thanks. And thank you to SCMA for this important dialogue. Very informative. All right. So thank you, everyone. Excellent webinar. I think so too. This was a great idea I had, wasn't it?
I want to thank Crystal and SCMA for putting together a program so quickly, and for the membership. There were so many of you that showed up. It exceeded our expectations. So I just want to thank, and I also want to thank my fellow panelists for working so quickly and diligently to put together this program. Thank you.
I feel the same way, and please join the California Dispute Resolution Council. We have a lobbyist and it's really necessary.
Excellent. Thank you guys so much for attending, and thank you to our panelists. All right. Have a great evening, everyone.
Thank you, folks.
Thank you. Good night.
Good night.